I'm going to have to rely on your help, Mike, because I guess you can see people. I can't do this on my computer. I'm doing this on my phone because my computer didn't work, and I tried it on a laptop that I don't have email on it, and this thing requires email back and forth. It's a whole long story. So I may have to rely on you to tell me who's if anybody's signaling or raising their hand or anything like that, because
we'll get there.
Because I'll have no idea.
We'll get there.
Okay, I'm also going to have to use my phone both for this and for all the information. I
think Blay, you froze. Stand by, everyone. Oh, there you are. Now we lost your audio.
Call in from the audio.
There you are.
Oh my God.
Everybody, please stand by. We'll get this sorted out. Blay, if you can hear me, you may need to just drop out and drop back in. And thank everyone for your patience and apologize for the technical difficulties. We'll get this sorted out.
No worries, no hurry. We're good.
Okay, can I?
You can mute or unmute yourself at pressing star 6. You are unmuted.
Okay, can everybody hear me again?
Is this 516 your number?
Yes.
Okay.
All right.
Wait, now I got to shut audio. There we go.
Whoa.
Oh my God. I got to shut off my audio on the Zoom. Mike, can you do that for me?
You are muted on your Zoom, so I think it's picking up the phone is picking up the speaker echo from the Zoom.
If you try turning off your system audio for the Zoom and leave it only on one device, then it'll probably be okay.
Okay. I can now, I think, speak on one and. Oh my God, that's no good.
You still got the Lou Gehrig thing going on.
That's no good. Better?
Still echoing. Try it now through your phone.
If you try turning off your computer or phone audio on one so it doesn't put any sound through, and then keep the mic muted on that same device. It should be okay.
Hey, Blake, talk through your phone rather than through the Zoom and see how it sounds.
Ken here. I'm going to step away for a minute. I'll be back in about 60 to 120 seconds.
No worries. Folks, I'm going to pause the recording for the moment just because there's nothing to record. Okay, we're ready to go.
Okay. Thank you, everybody. Oh my God, it's doing it again.
Yeah, it is.
If I could suggest, if your computer has any sound on, your phone microphone will pick that up and rebroadcast that, and that'll make the loop. So if you mute your computer audio and use your phone line.
I'm killing the Zoom on the phone. So I'm just going to only be on audio on the phone, on the landline. Okay, that should solve it.
Yeah, you sound
Sounds better to me.
Yeah, I killed my Zoom on my phone. It wasn't doing me any good anyway. It was helping you see me, but that's it. Okay, very good. So if we look at the schedule, I guess it's appellant up first for 10 minutes, and you can reserve some time at the end if you like for a reply from the respondent. So appellant, Mr. McGee, is it Mr. McGee representing the appellant?
No, Mr. Martin is the appellant. Mr. McGee's for the LNC.
Oh, I'm sorry. Yes, you're right. Mr. Martin, please go ahead.
No worries, and thank you. Members of the Judicial Committee, thank you for taking the time today to hear this case, and thank you for your continued service to the party. I am Austin Martin, chair of the Libertarian Party of Hawaii and a member affiliate member of Region 1. Region 1 representative, alternate, elected by the same Region 1 election that put James Wiley in the same role. Today is about whether or not the Libertarian Party will be governed by its bylaws or by ad hoc decisions of its officers. The facts are straightforward and largely undisputed. On May 10th, Region 1 duly elected Mr. Wiley as its second alternate representative. No one at the time objected, and no notice of ineligibility was given. No process was initiated. Days later, based solely on an internal determination about a supposed dues lapse, the chair unilaterally declared the election void and ordered a new one. That decision was later sustained by the LNC when a point of order attempted to invalidate the unilateral ruling of the chair. There were no charges, no notice, no hearing, and no removal vote, just a declaration. So we must ask, where does the authority to do that come from? Not from Article 7.8, because that provision gives removal authority to the region, not to national officers. Not from Article 7.4, because while it requires sustaining membership, it does not define any automatic forfeiture mechanism. And importantly, the respondent concedes this point. There is no explicit rule providing that a lapse in dues automatically suspends membership or eligibility. That concession is critical. Under Robert's rules, a member in arrears retains their rights unless the bylaws explicitly provide otherwise or disciplinary procedures are followed. Neither occurred here. So what did the LNC do? It created an unwritten rule that a lapse in dues automatically eliminates eligibility and then used that rule to invalidate a completed election. That's not interpretation, that is legislation. And it was done not by the delegates, not by amendment, but by an officer action after the fact. Karen Ann Harlow submitted an amicus attempting to salvage the LNC's position by reframing the issue at appeal as a removal, allowed under the Region 1 agreement. But that argument only sharpens the problem, because if this was a removal, then it required a defined procedure, notice, a vote, compliance with the same standards applied to at-large members. None of that happened. Instead, what occurred was something much more troubling. A removal in substance without any removal process in form. And even more striking, Ms. Harlos, who is involved in the events addressed in this appeal, is advancing this argument as a drafter of the Region 1 agreement itself, an agreement which cannot override the national bylaws, and which presumes formal process, not unilateral nullification. We're left with a fundamental contradiction. If this was not a removal, then there is no authority to void the election. If it was a removal, then no valid process was followed. Either way, the action fails. The party officers may invent eligibility rules not found in the bylaws, apply them retroactively, and nullify elections without process. That is not how a deliberative body governed by the rules operates. It's precisely why parliamentary law it's just why we have it. I think this is not the first time that we've seen this kind of behavior from the factionless majority on the LNC. The same theory was used in the Vincent matter, again invoking automatic consequences for lapsed dues, again without proper procedure. This is not an isolated error, it is a pattern, and it is illustrative of the Lee Wrights case in 2009. It's a long-standing pattern of the LNC to ignore the principle of due process to gain an advantage over other members in intra-party disputes. The respondent and Ms. Harlow suggest this case is moot, but mootness does not erase violation of the governing rules, especially where those violations assert authority that does not exist, affect how future elections may be handled, and are capable of repetition. The Judicial Committee's role under Article 7, Section 12 is not to advise or weigh in on intra-party disputes, but to determine whether an LNC action contravenes the bylaws. The Judicial Committee is here today to answer one question. Did the LNC's action contravene the bylaws? And the answer is unequivocally yes. The bylaws say who elects, removes, and replaces regional representatives, the regions. They say what eligibility requires, sustaining membership but not automatic forfeiture. They say nothing about officers voiding elections. And Robert's rules clearly says you cannot deprive rights or office without following proper procedures. The LNC bypassed those rules. And when rules are bypassed, the remedy is clear. The action must be declared null and void. I want to, before I just break off on my opening statements here, I care about due process tremendously. It is one of my fundamental things that moves me as a libertarian. If the government passes a law that makes it illegal to, hop around on one foot, as silly as that law is, you think, okay, I can comply on that. But if they don't have due process, anything can be construed as a violation of whatever absurd law that they want to impose on you. They can accuse you of doing things you did not do, and by circumventing process, they remove the burden from themselves to prove their accusations. I think it's important to remember that at the core, any perceived bylaws violation is an allegation until proven. Without proper process, there's no way to confirm this. It oversteps the authority of the region in this case. But again, this is part of a much bigger pattern where the LNC has been, honestly, I got elected into this role, and ever since my election, I've been fighting to keep myself from being thrown off in 10 different ways. It has been a nonstop assault on my membership rights. I've had my email removed. I have had my access to others cut off. I've had my participation in meetings impaired. It's literally every time. I could not take the number of cases that I could appeal to the JC if I wanted to. I've made it a bigger priority to stand up for others rather than championing my own cause. And so far, that's been fruitless. So today, you get to make a really important decision. Are we a dictatorship? Does the chair get to unilaterally make these kinds of determinations? And if so, I want to be clear that I will be taking notes. If that is what you guys think we can do, I disagree, and I think we need some serious rules changes, but I will use those rules if you guys rule against me in this proceeding. I would just point out that I think there's a lot of members of the party who have violated the bylaws profoundly and in much more significant and serious ways than a dues lapse. And if it's just up to my judgment as a party chair to be able to say, you violated the bylaws, goodbye, right? That's a lot of power you'd be handing me. So I don't think that's right. I don't think that's a proper exercise of my office. I think if I wanted to remove someone who is anti-NAP from the party, I would need to give them due process. And that's because I'm a libertarian. I hope you guys are with me on this. Due process matters. It's not something that we can override. But frankly, today, if you decide against due process, it's on, I got people to remove. So I really hope that you will void this action, do the right thing, and decide in favor of our principles and what unites us as a party. Without due process, you have no assurance that what is being claimed is actually true. And I'll give one last example. In my case, it was falsely alleged that I had not signed the NAP. And I believe this was accomplished through the alteration of internal data. And there's actually evidence to support this. That allegation that I would have been ineligible, right, was about to be leveraged against me when I blew the whistle on the data breach. It would have been an automatic removal. If this permission is granted to the chair, he could just say, I see you didn't check the box. It looked like it was checked a few weeks ago, but not anymore. So I'm going to just kick you out. And if that's all it takes, man, what stops me from removing anyone for perceived NAP violation? So I'm going to rest and withhold the rest of my time. Thank you for hearing me. And I hope that, I'd remind you, I don't think we actually need this hearing. So I'm sorry for taking so much time here at the beginning. I rest.
Okay, very good. You have 1 minute left, so I guess you're reserving that last minute. Mr. McGee, opening statement.
Yes, thank you. Can everyone hear me?
I can hear you. I don't know if anyone else can.
Okay, thank you.
Yeah, we can hear you.
Perfect. All right. Members of the Judicial Committee, today we consider the case of Martin v. LNC concerning the validity of the LNC's action to void the Region 1 election held on May 10th, 2025. The LNC respectfully submits that its actions were both valid and necessary to preserve the integrity of party governance and membership eligibility standards. On May the 10th, 2025, the Region 1 chairs elected James Wiley as second alternate to the regional agreement. However, okay.
The sound seems to be coming in and out. Is anybody else experiencing that?
Yeah, I'm hearing that too.
Yes, I am.
Okay. I'm not quite sure what to do about that. Can you hear me now?
Yeah.
I hear you now, but it comes in and out.
Okay. Well, I'll give it a good shot. It's unfortunate. Okay. So what was the last thing you heard?
On the date that they did the election?
Okay, perfect.
I would back.
All right. I'll go back to there. On May the 10th, 2025, the Region 1 chairs elected James Wiley as second alternate to the Libertarian National Committee, following the procedures outlined in the Region 1 regional agreement. However, during the onboarding process, it was discovered that Mr. Wiley's sustaining membership had lapsed, with his last contribution at the time recorded on March the 2nd, 2024. This lapse meant that his membership was lapsed by a full 2 months prior to the election, not during any tenure on the LNC. Based on the lapse in membership, the LNC chair instructed Region 1 to disregard the election and conduct a new one, asserting that the membership lapse invalidated Mr. Wiley's election. After being notified, Mr. Wiley promptly renewed his sustaining membership on May the 5th, 2025. At the LNC meeting held in Grand Rapids on May 17 and 18, 2025, Region 1 Representative Andrew Chatterton raised a point of order challenging the chair's determination, but the ruling of the chair was ultimately upheld, thereby rendering the election null and void. Subsequently, on May 24th, 2025, the Region 1 chairs voted to ratify the prior election and address the procedural defect now that Mr. Wiley's membership was current. The chair accepted this action and formally acknowledged Mr. Wiley's election, completing the process and confirming his status as second alternate to Libertarian National Committee. James Wiley was initially ineligible for election as second alternate because his sustaining membership had lapsed prior to the May 10th election. Under the party's bylaws, sustaining membership is a prerequisite for candidacy, and the election became final at the close of balloting on May the 10th, per Ronner Section 46, 46, and 47. Since Mr. Wiley was not a sustaining member as defined in the bylaws when the election became final, this constituted a fatal and continuing breach of Articles 7.4 and 4.4 of the national bylaws. Mr. Wiley's subsequent renewal of his sustaining membership on May the 15th, 2025 could not cure the breach by itself because eligibility is determined at the time the election becomes final, not afterwards. While the Region 1 chairs later ratified the election after the renewal to validate the results of the original election, such ratification cannot retroactively validate the original election if eligibility requirements were not met at the pertinent time. The rules require that only eligible candidates be elected, and correcting membership status post-election does not alter the fact that the breach occurred when the election took effect. The chair and National Committee possess clear authority under Article 6.3 of the national bylaws and Ronner 46, 48 through 49 to contest and void election results that violate eligibility requirements. The chair's decision to declare the election invalid was upheld following a point of order raised at the May 17th meeting, confirming that the election of Mr. Wiley was null and void. The Region 1 ratification further acknowledged the procedural defect, underscoring the necessary of strict adherence to bylaws and parliamentary rules in party elections. The petitioner asserts in this matter that membership rights were suspended without proper notice or were otherwise violated, and at a minimum suggests that the actions taken by the LNC amount to a removal, drawing comparisons to the cases involving Lee Wrights and Robert Vinson. This characterization, however, is fundamentally flawed. It is essential to first clarify the precise nature of membership rights, as the rights and privileges of a sustaining member differ significantly from those of a National Committee member. In the instances of removal from the National Committee, members of the committee are afforded extensive due process protections, while sustaining members who are not National Committee members are not entitled to such procedural safeguards. In fact, the very idea that a sustaining member who is not a member of the National Committee has a due process right that protects them from being removed from the National Committee is quintessentially nonsensical. Equally nonsensical is the notion that imposing eligibility requirements on National Committee membership is somehow a violation of sustaining membership rights. As cited in the respondent brief and by Mr. Jonathan Jacobs in his amicus brief, the controlling rule in this matter is Ronner 4649A, which states, if an individual does not meet the qualifications for the post established in the bylaws, here National Committee membership, his or her election is tantamount to adoption of a main motion that conflicts with the bylaws, hence a sustaining and continuing breach of the bylaws. The petitioner has attempted to use the similarities between the Wrights case and this one to suggest that the Judicial Committee should reach the same decision it did in the Wrights case. However, it is the differences between these two cases that is most important. In fact, the last paragraph in the majority opinion in Wrights states, and I quote, "This is not to say that the Secretary is required to allow an at-large member who has lapsed all of the rights and privileges of a member in good standing. The Secretary could refuse to acknowledge the votes of an at-large member he/she believes to be ineligible to hold the office. The Secretary and Chair could refuse to seat an at-large member they determine to be ineligible. What they cannot do is suspend an at-large member from the National Committee without following the procedures in the bylaws. The key distinction between Wrights and Martin lies in the procedural handling of sustaining membership lapses and their impact on seating versus removal or suspension from the National Committee. In the Wrights case, Lee Wrights was duly elected as an at-large member of the National Committee, but his sustaining membership lapsed during his tenure on the committee, resulting in his removal. Now, the Judicial Committee ultimately reversed that suspension, emphasizing that removal or suspension of a National Committee member must follow the procedures outlined in the Libertarian Party bylaws rather than on any ad hoc actions by officers. In contrast, in Martin v. LNC, Mr. Wiley's situation involved a lapse in sustaining membership prior to being elected or seated as a second alternate to the Libertarian National Committee. He was, quote unquote, elected, but was not seated at the May meeting because his eligibility requirements were not met at the time of the election. Importantly, Mr. Wiley was never suspended or removed from the National Committee. He simply was not seated due to an ongoing in Rights v. LNC, where the secretary and chair could refuse to seat an eligible member. Both Martin and Rights underscore the necessity of distinguishing between seating procedures and suspension/removal procedures. The Rights case clarified that while officers may refuse to seat a member who is ineligible, formal suspension or removal must adhere to default procedures set forth in the bylaws. In Martin v. LNC, Mr. Wiley's case illustrates this principle. His membership lapse prevented him from being seated, but no suspension or removal occurred, highlighting a critical fact pattern difference between the two cases. While the Libertarian Party recognizes the principle of regional autonomy, such autonomy is necessarily bound by the party's national bylaws and the overarching authority of the LNC. Regions are empowered to conduct their own elections, but must do so within the parameters established by the party's governing documents. Where regional actions conflict with national eligibility standards, the LNC has both the right and the obligation to intervene. For the foregoing reasons, the Libertarian National Committee respectfully asks that the National Judicial Committee not declare the LNC actions in this matter null and void. Thank you, and I welcome questions from the committee.
Mr. Chair.
Oh, sorry, I muted myself. Thank you, Mr. McGee. Mr. Martin, would you care to use your 1 minute remaining for any kind of reply?
Yes, I will, and thank you, Mr. Chair. First of all, I would like to start by clarifying that Region 1 did not at any time re-elect Mr. Wiley. We held that our original election was valid and that the curable lapse, which was discovered after the fact, was in fact curable and not a fatal issue. And if that were mistaken, then the LNC would have been mistaken to seat Mr. Wiley in the December meeting because according to them, he was never actually elected. So in my opinion, the interpretation that they're putting forward just is nonsensical. He at no point did we re-elect him. So if the election was invalid, no amount of ratification of our decision would, put a new person on the LNC. It would only just say that the original action is something we consider valid. So no number of ratifications will re-elect Mr. Wiley. And I think another key thing here, if this was considered like an auto resignation, which is, I think, the argument that some have tried to make here, that it just simply doesn't satisfy. It's an argument from silence. Thank you.
Okay, time is up. Thank you, Mr. Martin. Mr. Latham, do you have any questions?
Yes, can you hear me?
Yes, we
I can hear you.
Great. First questions to Mr. McGee, and I'll direct you to page 5 of the LNC's reply brief. And kind of in the middle there, it's at, I guess, the third sentence that starts, at this point, the breach of Articles 7.4 and 4.4 of the national bylaws became a fatal and continuing breach of the national bylaws. I'm just going to check in with Mr. McGee to see if he's there and knows what I'm talking about.
Yes, I know what you're talking about.
Great, thanks, Mr. McGee. And then the sentence right after says the renewal of Mr. Wiley's sustaining membership on May 15, 2025 was not sufficient by itself to cure the breach since it could not have changed his eligibility status at the time the election took effect. And the LNC didn't really offer any kind of support from our parliamentary authority. I I can say I think Ms. Harlos, one of her amicus briefs, cited something from National Parliamentarian, but that was it, and I could never find the underlying citation of that. Is there any other support of that position that Mr. Wiley going and renewing his sustaining membership was not enough by itself to cure the breach?
Well, I did actually post on the previous page of the brief the section in Ronner at when an election takes effect, and it tells you when eligibility standards are to be applied.
Okay, and I get that argument, and I will.
If there's
I'm not,
go ahead. And then I also mentioned in my opening statement. Okay, I also mentioned in my opening statement that I believe it was 49 or 4649A, which states that if anyone for an election fails to meet eligibility requirements, that election necessarily becomes tantamount to adopting a main motion that is in direct conflict with the bylaws. That is by definition a continuing breach.
Okay, no, thank you, and I think we're clued into that. I do want to point out, and maybe when you have some downtime during this hearing to take a look at it, the following section in Ronner 4650, and others on our committee have kind of brought this up, talking about the voting body itself as the ultimate judge of election disputes. And so the thinking behind that language might be maybe it's not the LNC that is the voting body here, but it's actually Region 1. So I don't want you to answer that now unless you think you have a ready answer, but I encourage you to be thinking about how to address that language in Ronner. Did you want to take a stab at that right now, Mr. McGee, or did you want to think about that a little?
Give me a second to look up the section.
Okay. Well, tell you what, let me put a pin in that, if you would, because I just had one more question for you and then also for Mr. Martin, and then I'll yield my turn to the rest of the committee. Question's this. If this committee decides that the LNC should have just declined to seat Mr. Wiley until his sustaining membership had been renewed, and I think I heard you say a couple different times that was an option for the LNC to do here, just we're declining to seat you because your sustaining membership's not valid. So rather, how about do that, decline to seat him, rather than declare that Region 1 election void? Why, if this committee, Judicial Committee, decided that, why would that be incorrect? So that's the question.
Is this directed to me?
Yes.
Okay. I mean, I'm trying to figure out what the difference is between this question and the previous one, because it seems to hinge on the interpretation of whether or not the final determining body is Region 1 or the LNC. Obviously, the appellant thinks it's Region 1, is going to think it's Region 1, and obviously the respondent is going to think it's the LNC.
Oh, and the respondent is going to think it's, and I think you were going to say
I'm not sure
the LNC.
I'm going to have a very satisfying answer to that question.
Okay, well, and I think that's like I said, yeah. Well, they're related issues there. I think that Ronner section and that question are kind of related. I'm going to kick it over, and you can certainly return to that question, I think, as you're responding to others later on in this hearing. I'll put it the same question to Mr. Martin. Same question. So you've asked for a lot of relief, but what if this Judicial Committee just decided that what the LNC should have done here is just decline to seat Mr. Wiley until his sustaining membership was renewed, rather than say that the Region 1 election is void? Why would that decision by this Judicial Committee be incorrect? Mr. Martin.
I'm not entirely sure that, thank you for your question. I'm not entirely sure that it would be incorrect. I'm kind of giving that some thought. One thing that occurs to me, and the biggest thing that I would be concerned about would be abusability. If they decline to seat a member, that could involve the suspension of membership rights if it were found that that declination were done improperly. So if it were not well founded and it were based on, say, somebody altering the database and unchecking someone's membership pledge box, and they say, well, we don't have any evidence that you pledged the NAP, you know, and then they simply refuse to hear evidence on that, like that could be used to push people out wrongly. The cure for that would be to come here to you guys and explain the situation, and then that would be reversed. So that's kind of where I'm trying to puzzle out, is that incorrect? I generally tend to err on the side of membership rights. So if I were making this call, I would feel like the committee itself would need to vote. I think if they wanted to invalidate that election, I think at a minimum it would have required a 2/3 vote, and I'm not sure they could have even done it then. But like for not seating someone, I really think that that should be a question to the body and not necessarily a question for the unilateral determination of an officer. That's my personal opinion on it. I'm not sure if we can call that correct or not. But my concern mainly is to make sure that we don't subvert the purpose of regional representation and representation rights in general. And that does seem to be a major problem in our party history. You'd think it wouldn't be because of what we stand for, but unfortunately, the reality is that we play very ugly games in this party to try to silence voices that we disagree with. And I think it's really important that we err on the side of protecting those voices, even if they may be a little inconvenient sometimes. You're not losing anything by allowing those people, unless there truly is an eligibility issue, which the body should be fully capable of determining. That gives everybody the benefit of process and the ability to come with the record. This was made like off the cuff. There wasn't even a written objection. There was no process. And so we had no real, opportunity to do anything about it. We just were notified that our political voice was invalid.
Okay. Well, Mr. Mimar, I'm going to leave it there. But I think there's no disagreement that at the time of the election, Mr. Wiley's sustaining membership had lapsed, right? There's no, that's not in dispute.
To my understanding, that's correct. However, when you have a confession, like a real legal situation, that confession is a piece of evidence. It doesn't automatically negate and remove due process protections, right? And I think there's a recognition that no matter how convinced we are that that's the case, we need to recognize that it's possible for someone to have this allegation and it not be true, right? And especially with our record-keeping procedures in this party, like this is dangerous territory, guys. We could really have a gotcha situation here, and that's what I'm worried about.
Thankfully, it doesn't look like we have that here, but your concerns are duly noted. Mr. Chairman, that's all the questions I have for this round. Thank you.
Okay, thank you, Mr. Latham. It's my turn now. I'd like to start with appellant. So, Mr. Martin, it seems that we have a bit of a conflict or friction between Article 7.4 of the bylaws that requires members to be sustaining members of the LNC to be sustaining members, and Article 7.8 that requires removals to be done by the region. Would you say that that Article 7.8 overrides 7.4, and that rule, and there are other rules in there too, that other requirements of members of the LNC? Would you say that all of those requirements of the LNC are necessarily don't apply to regional reps because of 7.8?
Thank you. I appreciate the tension that you highlight there. And actually, I would not say that it overrides it in any way. I would say that those requirements are perfectly valid and binding on everybody. The question is not whether those standards apply to regions. The question is one of process, authority, and threshold. It is not a matter of whether or not one part of the bylaws can do violence against another part, but rather whether we can harmonize these different parts of the bylaws. So if I believe a bylaw violation has occurred, there's a process by which I would vindicate that, whether I'm the chair or an at-large member, right? And that process is designed to protect all parties, not just the defendant, but also the party as an organization. So my feeling is that if he, as a member in arrears, if indeed there is an issue there, there would have been a better way to adjudicate that, to bring it up, to do a suspension. There are processes that we could have accessed, but it was inconvenient. So the issue is not whether these, in my opinion, his membership status doesn't even come into it. We don't get past the threshold of this is a unilateral officer determination affecting member rights and region rights. And even if the region is wrong, there is a process by which the LNC can enforce the bylaws on the region. And that process is not by unilateral determinations of the chair. So I don't think there's any conflict between the different portions of the bylaws. I think they go together perfectly, and that those requirements are very important. However, I don't think we get to unilaterally impose them because we think we're sure, no matter how sure we think we are. I mean, the records may have really reflected that Mr. Wiley was in arrears. What if it was a card error? What if his profile had changed? What if there was a database problem? There are reasons why this could happen to others. And then the same kind of decision could result in egregious membership rights violations because we have circumvented the due process requirements that would protect someone in those situations. So again, I say it fails at the threshold. As far as membership rights, as a member in arrears, I don't think his rights just instantly get terminated. So there still is a necessary protection for him that would prevent the chair or the LNC from making a snap determination. Whether or not you'd have to follow a full-on disciplinary thing, or whether you could do a 2/3 vote to remove, or not remove, but suspend, like a temporary suspension until it's cured. I don't know. Like in that process, we could talk about how to get through that as a committee if that were brought up to me. But one thing that wouldn't have been on the table would have been me just invalidating the election of, like an entire county in my state and saying, oh no, that doesn't work. Like if I felt that
Can I
way,
answer?
I would bring a motion.
Mr. Martin, if is there any circumstance under which the LNC could remove a regional rep? I mean,
well, according to our regional agreement, whether or not this is germane to the bylaws, I suppose, is something that hasn't been tested. But according to our regional agreement, there is a process that the state chairs have consented to in order to remove or suspend a region member. We only ask that they get the benefit of the same due process rights that would be afforded to any other member where there's a controversy about their eligibility or fitness to serve. So,
well, barring that consent, I'd like to just speak to the bylaws. Where the line is in the bylaws, and not where the region has consented to, assuming that would even be valid consent under the bylaws. But
you raise a good point.
Suppose somebody refused to make a donation, and I would also distinguish. You spoke of the member being in arrears. I believe arrears would apply to a dues payment, and I don't think this has anything to do with the dues payment. If you look at the bylaws, it says that it's somebody who has donated to the party. This is not a dues requirement that the person has not fulfilled. In other words, I don't have the Roberts site, but it says in Roberts that if you do not if you fail to fulfill your dues requirement and you resign or are kicked out of the party, the dues requirement continues to accrue. In this case, there is no dues requirement at all. This is just a question of whether the person has made a volunteer donation to the party. He's under no obligation to make such a donation. So I'm not sure the arrears language is appropriate. But suppose he refused to make this donation. He said, I'm not going to make a donation. I don't care. You can't do anything to me because Article 7.8 says that only the region can kick me out. You can't kick me out. And let's say there was no agreement between the region and national. Would you say that Article 7.8 protects him from being kicked out, even if he refuses to make the donation, or does something else? Or do you think that with the LNC does have the authority to kick out the member under some circumstances?
You raise an excellent and thoughtful point on this, which I really appreciate. To give you the simplest answer, let's say Mr. Wiley said, I'm not going to pay. The region has the right to send who they send, and you can't stop us. I would actually think that there is authority for the LNC to enforce the bylaws, and that they should do so. However, the one thing they must not do is have an officer unilaterally exercise that authority without any proper process, right? If there is a bylaws violation, then it absolutely can be addressed in the committee. There's no reason why it couldn't. And I don't think that the presumption of guilt from the outset, say they're very confident that Mr. Wiley did not pay his dues and or his donation requirement or eligibility requirements. And so because they're convinced of that fact, they proceed. But I think that they would need a 2/3 vote to do that, personally, at least. But I'll take it a step further. What if Mr. Wiley said, I'm not going to pay that because I've already made that donation? If he said that, right, that would be a similar situation. And where if the LNC decided to act in this way, Mr. Wiley would have no opportunity to show that he did, in fact, meet those requirements. And he would have the ability to do so. He could make the argument that he, donated through another event that we've had this discussion about what constitutes a donation.
If I may, you don't disagree with the LNC having the authority to do what it did. You just don't agree with the procedural way that they did it.
As a body, I believe that the LNC has the duty to uphold its bylaws, even though the bylaws protect regional rights very robustly. And they do require that there are, bylaws requirements that are effective on the regions. And I believe those could be enforced. I believe that those would have to be enforced with the full authority of the LNC through proper process and not by unilateral determinations. So, yes.
Okay. One more question. It has to do with the practical effect of all of this. Was Mr. Wiley, I don't recall seeing this in any of the history or the fact patterns, either one. Was Mr. Wiley ever denied being allowed to sit at the table, or was he not put on a list? What was the practical effect, in other words, of the chair's statement? I mean, the chair has the authority to make all sorts of opinions. His opinion, arguably, was that the election was invalid. I believe he's entitled to make that opinion. I believe everybody is entitled to make that opinion. How did making such an opinion violate the bylaws? Did the opinion itself violate the bylaws, or did he take some action taken by the LNC that did violate the bylaws?
Thank you. Those are two very excellent questions. Let me start with the latter first. Was there a definitive action? The chair did not merely express an opinion. He, in his official capacity, invalidated the will of a huge portion of the party state chairs in an election that he was not party to and not present for, where no objection was formally raised in any kind of meeting. So he took an out-of-meeting official action, which allegedly invalidated the election. I tested that authority by not agreeing to reelect Mr. Wiley, but to ratify it, to prove that he did not have that authority and that indeed Mr. Wiley was elected. And if I was wrong about that, he would not have been seated at Dallas. So in a sense, we're looking at a defunct action that required an unnecessary vote from the LNC to stop the point of order that I raised. But the practical effects are really relevant. I want to dovetail into those. So he unilaterally ruled our election invalid and informed Mr. Wiley in advance of the event that he would not be seated. This is critical because this is where the practical effects really kick in. Mr. Wiley was planning to come and take over the last day. I had travel plans. I don't have a lot of money. Getting from Hawaii to Grand Rapids is a huge effort. It's not easy. I planned to return a full day, 2 days more, before I actually did. When Mr. Wiley would not be seated, we would have been down a vote. Our region would have been seriously impaired. We would have not been able to take part in critical business that was occurring at that meeting. So I canceled my flight, and it cost me over $1,000 out of pocket so that I could move everything around. And it was chaos and totally screwed up my personal financial life in a big way. To scramble and cover for the actions of the chair and the secretary, which in my opinion did not serve party interests and were not about enforcing the bylaws, very much about a personal dispute that I believe Mrs. Harlos has with Mr. Wiley. But regardless of my opinions on that, Mr. Wiley decided not to come. It's a lot of travel to come that far and not be able to participate. I can understand why he made that decision. So the practical effects were devastating in our personal and our regional representation strategies. It hurt us. It sucked. And it's hard for me to articulate the full extent of those practical effects.
I understand. I would question the very first thing you said, which was that that the chair invalidated the Region 1 election.
You're correct. I probably said that.
Did he invalidate the Region 1 election? Did he succeed in doing that?
No, but he did succeed in discouraging and preventing Mr. Wiley from appearing and being seated based on a false assertion that overstepped his authority. So while he did not successfully do so, it was his act that directly prevented Mr. Wiley and prevented my travel plans. And then on top of that, just from a practical standpoint, he would not have been seated unless we got something from the region that affirmed after he had cured his dues lapse that we basically still wanted him. And I think the point was that there was organizing going on in the region to try to flip votes because it was narrow. And they thought that if they could put some of Mr. Wiley's more embarrassing social media posts out there to the state chairs, they could get another bite of the apple. And they thought we might not be able to get a majority if we had done so. And so I think they were actually trying to put another person in that seat. And that was the intent behind it.
Okay. So I guess what you're really saying is that there was the fact that the chair announced in advance that Mr. Wiley would not be seated had a chilling effect and prevented Mr. Wiley from coming. He did not want to come and challenge that on the possibility of not being allowed to be seated.
Yes, that, and it did require me to go and spend the political capital of whipping our entire region into yet another vote. All of our chairs were not happy about that. That was very frustrating and discouraging for them. Whether or not their action to nullify the election succeeded, in my opinion, no. But in the opinion of some of the people here, they believe they did, and they are counting our ratification action as a re-election to kind of reinforce their delusional take that the chair can just invalidate an election unilaterally. And I do think that's delusional. I'm not trying to be mean. I think that is so far away from libertarianism that it's a little bit baffling that we even have to kind of go over this. To me, the question about the rules, I'm not contesting whether or not they should be applied. My only real concern here is the preservation of member rights through due process. And I believe that is not being followed by the LNC, and that is a fatal defect on their actions taken with regard to Region 1. Whether we consider it a invalidation of the election, an improper removal of a member, or a improper suspension, which I actually think what they did was a de facto suspension of Mr. Wiley without a vote. And I think that's the most coherent explanation of what occurred, but that's my opinion.
Okay, well, would a suspension have been? I'm not sure I agree with that characterization. A suspension would have said you may not participate until such time as you cure your defect of not being a sustaining member. He cured the defect or the ruling. So I'm not sure how it was a suspension. It seemed to me it was a well, okay. I guess it could also be considered a suspension until such time as you are elected, but it wouldn't be a suspension. It's saying you were never validly appointed to this position. So
you're correct.
I would the suspension.
The one thing there, he was never reelected though. Stephen clarified his halfway concession to me was if I could get a majority of the chairs to affirm that they did in fact want to continue voting for Mr. Wiley and did not want to change their votes, that at that time he could participate again. It was unclear
thank you,
whether or not.
Thank you, Mr. McGee. A couple of questions, if I may.
Of course.
Do you distinguish between an election and an appointment? Are they the same thing? Is an appointment a form of election?
I mean, I think it would depend on the context. Because for example, within the context of the LNC, there is, you could argue that the only actual proper elections that happen of LNC members happen at conventions, and that any votes by the committee to fill vacancies is technically an appointment. So you could argue something like that, but I think at least with regards to the current case at hand, I don't think there's a functional difference between election and appointment. At least not with regards to the controlling mechanism in Ronner. Does that answer your question?
So can a region appoint a member of the to the LNC, the regional rep, or does the region have to elect?
That would probably depend on the Region 1 agreement, and if I recall, it requires an election.
Okay. So then are you saying that that the LNC found the region's selection invalid because it violated its own rules and not because it violated the national rules?
No. The mechanism for finding it invalid was the fact that elections require that someone who wins an election has to actually be eligible for the office being elected. And in Ronner, that's pretty clearly required. And
what about Region 1, though? Did Region 1 require that? Was the Region 1 an election or an appointment? What Region 1 did to select its regional rep, was that an election or an appointment?
I would say it was an election.
Because what feature of the selection constituted an election? Because the members voted?
Well, because the chairs who are responsible for forming regions and would thereby be the constituent members of the region were all present and there to elect their representative.
So this was an election not by the region, it was an election by the chairs of the region.
Well, because those are the people that are entitled to cast votes, or whoever they designate.
So you would consider that an election because the chairs voted.
Yeah, it's a region election because that is the constituent body that was making the decision.
Well, isn't the constituent body of the region all of the national members who are who reside in that region, or you know, maybe reside isn't the right word, but are assigned from that region, or you know, adhere to that region? Aren't those the members?
I mean, how do you figure?
Well, if you have a regional meeting, you have a regional caucus at the convention, don't all the members from the constituent states get together and vote and elect a regional rep normally? Or is it only the chairs normally that elect?
It's done by the delegates. Well, I mean, it can be done by the delegates. I think actually in the situation of the Region 1 this past time around, I don't think they actually caucused in DC. I think the chairs got together, you know, and independently determined to form the region. And so I would think, based on those facts, that, yeah, the chairs are the, you know, constituent members of the region, and thereby it's an election.
So you're saying, if I'm getting you correct, and correct me if I'm wrong, it sounds like you're saying that because the region chose to select its regional rep in this way, organize and select its regional rep in this way, because it chose to do that, that then subjected it to certain national rules. If he had done it differently, they would not have been subject to those national rules. Is that right?
I don't think that's the only reason why, but you know, actually, now that we've discussed it, I think it's certainly a reason why you could say that. Yes.
I mean, suppose the region had gotten together and said, look, you know, we don't know what we're going to do. We're just going to appoint the chair of the largest state in the region. We're going to appoint him to be the chair of the region. And he can select the delegate by himself. Would that also be an election because it's one guy voting?
I mean, that's an interesting question. Because we actually do have a region that only has one member. So, I mean, I guess, would you argue that California doesn't actually elect, or that the Region 4 doesn't actually elect their representative just because there's only one state in the region?
Well, maybe they do, maybe they don't. I would say it depends on whatever rules they have, whether they elect it. But I would say I would distinguish between an appointment and an election. Okay. So if the region had appointed instead of elected, would that have violated any national rules? If they had appointed Mr. Wiley while he was ineligible, while he was not a sustaining member per the definition in the bylaws, would that appointment have been invalid in your opinion?
Yes, because I think in this case, there's not really a proper distinction. It's a distinction without a difference in my opinion.
So you would think he would have to be appointed again by the chair. He couldn't just correct his deficiency of not. He couldn't just pay the $25 and then take his seat. He would have to be reappointed.
Correct. Because that's the mechanism
okay.
for a continuing breach. It's one of those things. I want to set the record straight that the reason why this situation feels so capricious and like oh, the chair snapped his fingers and made this happen. Well, that's because that's the mechanism in Ronner to cure a continuing breach of the bylaws. It it's the exact same thing that happened in the Harlow's case, where her removal was declared null and void because her removal was in continuing breach of the bylaws, and so the delegates at convention snapped their fingers, and all of a sudden the removal never happened. This is a similar case because the mechanism being used is the same because the actual election was in continuing breach of the bylaws.
So if Region 1 created bylaws and said, we have the authority to elect and or appoint anyone we like as a regional rep, irrespective of Robert's Rules of Order, which we do not accept, would then would Region 1 have the authority to override Roberts that way?
I mean, I'm not actually sure. That's an interesting question. One thing I can tell you is that's not anywhere in the Region 1 agreement. Okay. Well, I don't know if the Region 1 agreement, I don't know if Region 1 is bound by Roberts. I don't know if there is anything specific. They have their rules. I just don't know. What I'm concerned about is it seems like the LNC may be taking rules that constrain its conduct of elections and applying those rules to the Region 1 election and saying, because if we did an election like this, it would not have been valid. And you're right, arguably. Let's assume that you're right. Therefore, because Region 1 did it this way, their election isn't valid, even though there's nothing in their rules that would prevent them from doing it that way, necessarily. I mean, I guess the counterpoint here is Region 1 not subject to the National Party bylaws?
Well, of course they are. Yes, they're absolutely subject to the National Party bylaws. The question is, is there anything in the National Party bylaws that requires them to prevent people who are ineligible for offices from being elected? Let's say somebody is too young, and they won't be able to take office. They're gonna become of age later on down the road, and so would they have to be reelected? That's really the question.
Okay, could you reestablish the hypothetical for me so I can at least attempt to answer it?
Yeah. Well, it's just basically that if Region 1 decides to elect or appoint somebody, if they were to find that, if they were to have rules that allowed them to appoint or elect people who are ineligible. I mean, Robert says you can't do that. You can't elect somebody who's ineligible. But if they created a rule that overrode that, or they found that in their opinion that doesn't apply in this case, then would that not be a valid election? Or would you say, no, the fact that the National Party can't do that means that the local party can't do that?
Okay, I think in that case, I think there would be a problem in the actual creation of a rule that is contradictory to what is outlined in the bylaws. Article 16 dictates that the parliamentary authority is Ronner, and so that it applies to all cases and shall govern the party in all cases to which they are applicable. I would argue that if you were to make a rule that basically says, oh, a region is just not going to use the parliamentary authority of the party, I'm not sure they would be allowed to do that.
Well, aren't all the rules in Roberts? Can't any rule in Roberts be overrode by the rules of the
by standing
party
by standing rules and bylaws?
Organization?
Sure. Yes, by standing rules and bylaws.
Well, not just bylaws. Any rule, right? Can't you just pass a rule that violates Roberts?
It wouldn't violate Roberts. It would supersede Roberts. And
okay, that would supersede Roberts. Thank you for that correction. Yes.
Again, I
mean, are you saying that Region 1 does not have the authority to supersede?
I suppose I don't think personally it's not a compelling line of reasoning. That would create some real issues. Like basically any region could just completely, reject the party's parliamentary authority just because they want to. I mean, that doesn't really create a consistency when it comes to the rules. I think that creates some major issues.
Well, if our Nassau County bylaws here, superseded Roberts, could National come in and invalidate an election because we didn't follow Roberts?
Well, no, but that's a different fact pattern. That's a local affiliate, and you've already accepted Roberts as your parliamentary authority.
Well, you're familiar with the Nassau bylaws?
Am I okay?
We have, but that's really not the point.
Okay, I guess the problem here is I'm not sure what the point you're getting at is, and I apologize.
Okay, the point I'm getting at is that now, personally, I believe that Region 1, by its own agreement, I mean, it published the rules of the election, if I recall correctly, that said something to the effect that you're free. Everyone here is free to vote for any eligible person. So I would say that probably by its own rules, Region 1 may have created an invalid election. However, there are ways in Roberts on points of order, and other means. I don't know whether they even have adopted Roberts or not, but either way, there are means by which an election can be contested. And for whatever reason, Region 1 never did that. So, right or wrong, perhaps the election was contestable, but nobody there chose to contest it. So that ends the matter. I mean, it's really up to the region to decide what its own rules are and whether or not it wants to enforce them. I don't see how National can come in and enforce Region 1's rules, and I'm still not 100% clear whether you're saying that you believe that election was invalid because they violated their own rules or because they violated national rules. So it seems to me you're saying that they violated their own rules, but isn't it up to them to decide what their own rules are and whether or not they violated, and even if they have, whether they want to enforce the fact that they violated it?
The argument is that they violated the national rules. If they violated their own rules too, that's great. But quite frankly,
what national rule did they violate?
They elected someone that was not eligible per the definition in the bylaws of sustaining member.
Is there something in the national bylaws that says that a regional rep must have been a member at the time they were elected or appointed?
No, but this triggers the section in Ronner that that is binding because it's the parliamentary authority that states
But
that
that's binding on national, not binding on them. It's right. You're again now. You're saying Ronner. Well, Ronner applies to them, not the national. Ronner applies to the national bylaws. Okay. Let me move on. My last question, and I guess it's to both of you, is and this is really what Mr. Latham brought up earlier, is why did you not? I'll ask you first, Mr. McGee. Why was there no mention of 46:50 of Roberts? You quoted extensively from 46:49 and I believe 48, but not 50. Why was there no mention of 50? And I can read what 50 says if you like.
I'm actually pulling it up right now.
Okay, well, I'll read it for everybody while you're pulling it up, all right? 46:50 says, because the voting body itself is the ultimate judge of election disputes, only that body has the authority to resolve them in the absence of a bylaw or special rule of order that specifically grants another body that authority. Thus, for example, when an election has been conducted at a membership meeting or in a convention of delegates, an executive board, even one that is given full power and authority over the society's affairs between meetings of the body that conducted the election, may not entertain a point of order challenging or direct a recount concerning the announced election result. Is that not exactly the situation here?
Honestly, I can't make heads or tails of it, so I didn't want to include it in my argument.
Okay. Mr. Martin, can you make heads or tails of 46:50?
Yes, Mr. Chair. And it seems pretty clear to me that any reasonable person could understand what you just read, and that the reason for the failure to understand is not an actual lack of understanding, but a very political desire.
Mr. Martin, I would ask you. It sounds like you're in the midst of an ad hominem attack, and I would caution you against making that.
Thank you, Mr. Chair. One point of information that I think would be relevant to bring up. Mr. Wiley, at convention, a delegate is not necessarily somebody who is defined the way that the LNC is defining a sustaining member. My understanding is that somebody who is a valid member of their state party can be added to a delegation and sent to convention with full rights, even if they have not donated to the national party. If I'm not mistaken about this, then it makes absolutely no sense to contend that Mr. Wiley, that his election was invalid, because he certainly was a member of his state party, and he certainly would have been eligible to sit on a delegation. And I think in that situation, if there was an issue with his credentials, it would have been curable. I have a hard time imagining that something like that hasn't happened in the past.
Okay. Can we just get back to the very specific question that I had, which is why didn't you? Well, it was to both of you. Why didn't you include 46:50 in your brief? Why didn't you bring it up?
For me, I'll just own it as I'm not an expert, and I've not read every bit of Robert's rules and learning every day. And I was aware of the spirit of that requirement, but not the citation. And I will chalk that up to my inexperience on that.
Okay, Mr. McGee, is there anything else you'd like to say on this?
Not particularly, though. I am enjoying the lively discussion in the chat over Ronner 5820.
5820. Should I look that up? I'm going to look that up right now, just for the fun of it. Even though I was done here, so much to everybody else's unhappiness, I'm going to take a few more seconds here. 58. Search. Caucuses. Sometimes caucuses are held of different groups of delegates, as for example, all from a certain district, territory, or other geographic area defined by the organization and they are similarly governed by rules generally. Okay, I'm not sure what that has to do with it, but maybe I'm just not smart enough to understand that. Okay, thank you very much, everybody. I now yield to who is next, Mr. Kinsella.
I have no questions.
Okay, in that case, I don't think Mr. Montoni is here, but if he is, Mr. Montoni.
I am here, and I have no questions either.
Okay, then Mr. Stratton.
Stratton isn't here, Mr.
Did I
Chair.
confuse Montoni and Stratton? Which one? Who had the problem? Okay, is Mr. Stratton here?
He is not here.
He's not here. Okay, I think I transposed Mr. Montoni and Mr. Stratton. Mr. Seebeck, any questions?
I do not have any questions.
Okay, Mr. Seebeck, do I understand that you have chosen to recuse yourself, or would you care not to answer that at this time?
I have chosen to recuse myself from this case, and I will give an explanation why. I was present in Grand Rapids when all this happened, and later on in the year, a Cult of Honor show for which I am a co-host did a show on this, and we commented on it, not knowing this was going to come before this committee. So I consider it to be inappropriate to take part in the proceedings of the case. I am only here to make sure we're managing the meeting itself.
Okay. Thank you, Mr. Seebeck. And you have no questions. Is that correct?
No, that because I'm recusing myself. No, I do not.
Okay. Well, you're welcome to ask questions if you like. Mr. Krawchuk, do you have any questions?
Yeah, just a few. Let me get myself going here.
Okay.
Hey there. My smiling face. And I'll be brief, fortunately. I guess my questions are for Mr. Martin. Can the LNC seat a non-member?
That's a good question. I don't believe that they could validly violate the bylaws, but I think they could do it. It would just not be valid. I would just say that's moot because Mr. Wiley was a member.
Well, from what I read in the pleadings, everybody agrees that for a short span of time he was not a member. Correct?
No, sir, that's not correct. Actually, I'll give you this information. I believe that Mr. Wiley, in fact, was a member and would have been eligible if he were going to convention, for instance, based on his state party membership in the region, and that would have made him eligible to hold this seat even if he had decided not to pay dues. But it is what it is.
I'm looking at your initial pleading under factual background. It says between until May 15th, the determination is made that he has not made the contribution. Is that a true statement? He did not make the contribution or membership?
To national, no, but that does not automatically mean he's not a member. I think that determination would have to be made by the proper body.
It does.
No,
Article 4, Section 4 says you have to. Please don't interrupt me, sir. Article 4, Section 4 of our bylaws say that you either have to make that contribution or $25 within the last 12 months. That
Sir,
was not
if
done?
I have not,
was done?
if I did not make that contribution, but I was a delegate to convention on behalf of my state party, where I am a valid member, would I be eligible at convention?
Was that a yes or a no?
About whether he paid I think you're conflating the issue of his eligibility with payment itself, and then assuming from the outset we can make that determination unilaterally, I just think it needs to be made by a body.
Was that a yes or a no?
I'm not
You
disagreeing.
didn't answer in paragraphs. Just look
Can
for
you
a short
repeat the
answer
question?
here.
Repeat the
Yeah.
question.
Did he make the payments as required by Article 4, Section 4?
I'm not sure.
Okay, that's an answer there. And I think that's going to limit it. And I just have one observation. People keep saying, oh, the Wright case was this, the Karen Ann case was that. None of that has any bearing on what we're saying here. There's no precedent or anything that the JC has required. I wish people would stop doing it. And also, some of the things that you're asking for in your remedies are things that are way outside of the Judicial Committee's authority. We can only negate or nullify a decision of the LNC. And if I get your document up here, you're asking for clarify the membership rights may not be suspended. We don't clarify that, sir. But all those things, I'll just stop right there. Most of those things are outside of our authority, and I wish people would just limit themselves. And I have no comments for Mr. McGee. I think you made very good points, sir. That's it. I will yield the rest of my time.
Was that a question?
Okay, are you done, Mr. Krajcek, or do you require an answer?
No, I didn't. I was just sounding off that people are asking for things outside of our authority.
Okay, thank you. It just seems like one of the litigants wasn't sure about that. Okay, rebuttal statements, 5 minutes each. Mr. Martin.
Thank you. Well, when I first filed this, I was under the operating assumption that the non-payment of dues was very much, like I didn't really think too far afield of that. But, bringing up the members in arrears distinction earlier in this hearing made me think of, well, he's got a point. And then think of the way that we interpret that for convention and credentialing and all of that. And suddenly, well, I should have put that in the original pleading that, Mr. Wiley might have been an eligible member. And that determination was just never made by the body. It was made outside of a meeting by the chair, which is why the question over whether or not he was or was not an eligible member is entirely secondary. The real trouble is bypassing the proper procedures, as I said at the beginning. And I believe this hearing has shown that that is what's happening here, is that there is a desire in our political games oftentimes to take shortcuts that can be very damaging and have real world implications on people and negatively impact party health and representation rights. Region 1 could have handled this. This could have just literally been handled by a phone call. It would have been no big deal. But it was the overstepping of authority that led us to where we are today and to increasing the tensions in the party. I mean, Region 1, that was a spit in our face. And it is my position. I believe that, especially after hearing everybody in this hearing today, it's pretty clear to me that Mr. Wiley could have probably attended convention even with that lapse in dues based on his membership status. And so it really seems questionable to me. But anyway, I just hope that we can stand for due process. As I said at the beginning, if not, we just got to clarify the rules by which we're operating. I hope that regional autonomy is respected. And I thank you all for your time and everything. I don't want to waste your time anymore with long statements. You guys have probably heard more than enough. And again, I thank you.
Okay. Thank you, Mr. Martin. Mr. McGee?
I'm just going to keep it brief. My rebuttal is really more just countering the characterization. Unless Mr. Martin has information that I don't, and he may very well. But at least to my knowledge, this situation all arose during the onboarding process, where Nikayla and the executive director were attempting to create the accounts for Mr. Wiley so that he would be have all the necessary things he needed for the Grand Rapids meeting in May 2025. And it was going through that setup that they discovered that his membership was lapsed. that to insinuate that this was nefarious, where there's no evidence to, at least to my knowledge, again, I could be completely wrong about this, but there's no information been provided to substantiate the claim that this was political gamesmanship. Now, I mean, anyways, I don't want to belabor the point, but the reason why the matter was handled that way is because the chair was effectively ruling on the matter. Uh, that might maybe that wasn't the appropriate way to issue a point of order, but I would say it was effectively a point of order, which is the correct way to cure a continuing breach of the bylaws, which again, reasonable people can disagree whether or not it was, but based on the documentation I've seen and the rules that I've seen, it did constitute a continuing breach, and therefore that was the mechanism you would use to cure it. Honestly, if that if that had been found earlier, the fact that the membership had been lapsed, and if maybe there would have been enough time for Region 1 to hold another ballot, and everything would have been a-okay. To address a claim made earlier by Mr. Martin that there's a real danger here that some sort of technical error with someone's membership dues or in a CRM could create really nasty situations. Well, in the past there have been errors like that, and once they were discovered, everything was remedied, and no controversy happened, to my knowledge. It's not the first time that the payment account has, or that the technology used to auto collect dues in constituent organizations has messed up, and really it's just a matter of pointing out, hey, that was an error. I had this set up, and the situation's remedied. The only reason that didn't happen here is because there wasn't enough time to remedy it under the procedures outlined by Region 1, which require, I believe, 3 days for a ballot to take place. And the time it was caught, there would be no way to actually hold another election prior to the actual in-person meeting in Grand Rapids. Again, if Mr. Martin wants to characterize that as political gamesmanship, that is his prerogative. But from my perspective, that's just an unfortunate bureaucratic issue. Anyways, I won't belabor the point anymore, and I welcome any further questions from the committee. Thank you.
Okay, thank you, Mr. McGee. Mr. Latham, do you have any final questions?
Yeah, Mr. McGee, if this committee were to say, well, in hindsight, the LNC should have just declined to seat Mr. Wiley until he got his, sustaining membership back in order. But in either case, where we're at right now, the question is kind of moot. I know we've heard from Mr. Martin. He's kind of addressed the mootness issue, and maybe the LNC has addressed it in its brief. I'm blanking on whether it's there or not, but can you just weigh in, and you don't have to, of course, on kind of that mootness question? If this committee decides, hey, this is maybe how we would have done it or recommended it be done in hindsight, but it's moot anyway, does that have any other implications that maybe we ought to be aware of as a committee?
That's a good question, but I think probably the best answer given would probably be Mr. Krawchuk's answer, that in some it really doesn't matter what this board decides, honestly, because there's going to be a new JC in 2 months, and whatever this board decides is ultimately going to be not binding on the next committee. So I would argue, yeah, that's a whole lot of mootness.
Thank you. That's all I have, Mr. Chair.
Okay. I have a couple of, I guess they're more statements than questions. We keep speaking of the lapse of the dues payment. I don't believe the National Party, I don't see anywhere in the national bylaws where dues are required. I see a definition rather than a requirement that people pay dues. I see a definition of a sustaining member as being somebody who has donated, not paid dues, but donated to the party in the last 12 months. No obligation. Dues are an obligation that are imposed on all members by the bylaws. There is no such obligation that I can see in the bylaws to pay dues. This is merely a definitional question. Is a person a sustaining member or not? Do they meet the definition? Definition says sustaining member is a member who's paid dues. So that's that. And I believe both parties have spoken of dues payment, and that doesn't. It's irrelevant. It has nothing to do with this case, I think. But I just wanted to make that point. I would apologize if I missed any accusations on the part of Mr. Martin against anyone in the LNC. Maybe I was not paying close enough attention, but I was under the impression that he was saying that these procedures would enable shenanigans, and that's why he is so concerned about the procedures. And he was not saying that these shenanigans necessarily occurred. I may be wrong about that, but I would choose to look at it that way, because any accusations of that would I believe would be improper. So that's it, and I would yield my time to Mr. Kinsella. Any final questions, Mr. Kinsella? Mr. Seebeck, is Mr. Kinsella still on the call?
Yes, he's still here, but he's muted.
He's muted. Okay, well, we'll come back to Mr. Kinsella. Mr. Montoni, do you have any?
I have no questions. Thank you.
Final questions. Okay, Mr. Stratton, I believe is not here. Is that correct, Mr. Seebeck?
Yes, it is. He's not here.
Okay, Mr. Seebeck, do you have any final questions?
No.
And Mr. Krawchuk, do you have any final questions?
Nope, I'm good. Thank you.
Okay, one last attempt to contact Mr. Kinsella.
No, I had no questions.
Okay, very good. I guess there being no further business, hearing no further business, the meeting is adjourned. Thank you, everybody.